My name is Mitch Simon. I've been practicing law in New Hampshire for over 40 years and been a professor at UNH Law, focusing on legal ethics for over 25 years. I'm a member of the Divine Millimet Attorney Conduct Group, where we represent lawyers in legal malpractice, disciplinary cases, and other related legal ethics matters. I'm often asked by lawyers what they should do when they receive a grievance from the Attorney Discipline Office. And although it probably seems a bit self-serving from one who represents lawyers, my best advice is to get experienced counsel to help you see the case clearly and to understand this complicated procedure. It may be that the price of doing that is less than you think because many of you will have malpractice insurance that covers disciplinary cases. You should check with your carrier. Even if you choose not to do that, it's really advisable to discuss the case with a trusted partner or associate. Regardless of what you do at that phase, it is critical that you immediately assess honestly and fully the strength of the complaint against you. You have to figure out whether or not you did violate the rules, what the context of that violation is, and whether or not there's aggravating or mitigating factors. Only by doing this can you develop a strategy that will give you the maximum chance of avoiding sanctions. If you and counsel decide that the grievance is not supported, it's critical to respond to the Attorney Discipline Office. You'll find in your letter that they will say that the response is voluntary. My advice is to respond. This is the time when you can get the case thrown out and you want to advocate and provide assistance to the general counsel. This is also a time where you can get diversion if it's a minor mistake and not something that's serious. The key point, if you decide that there is some type of violation, some type of exposure, is to immediately figure out what type of sanctions you're looking at. I think here is where our training as civil lawyers in particular can betray us. We're often used to keeping the balls in the air, defending the case, hoping new facts come out, that a settlement can be reached. But what you're going to find in disciplinary cases is the exact opposite applies. Whether or not you cooperate with the disciplinary office, whether or not you express remorse, those are going to be critical factors in whether or not you have an ultimate suspension or something else that's very serious like disbarment, or whether or not you can get a reprimand or something else that at least will allow you to continue practicing. In essence, putting up a tough defense and losing the case is going to have additional consequences in the disciplinary system. You need to try to figure out how the ADA sanctioning guidelines would apply to you and whether you're looking at something serious like a suspension or something unpleasant but certainly less serious like a warning or an admonition. It's always a bad experience to get a letter like this, but I really urge you not to freeze, not to sit back and think it'll go away. It won't. You need to address it. You need to take care of it. We here at Divine Millimet would be happy to help.